So the state filed a motion for pretrial detention pursuant to Florida statute 907.041. And because this charge is still considered a dangerous crime, even though it's filed today, I'm required to hold you with no bond. So.
Arrested for a crime in Florida, you go to bond court and you're held no bond. There are a few reasons why that may be. Let's discuss those reasons. You are out on bond when you are arrested for a new offense. One of the conditions of release when you are out on bond is that you do not break the law. If you're alleged to break the law and you're rearrested, your bond on the first case will be revoked. Depending on the nature of the new offense that you picked up, you can be held no bond for violating the conditions of release. 2. You are out on probation and you are arrested for a new offense. Now, you're facing a possible new case and your probation violation. In this instance, you are not entitled to a bond. And it will be up to a judge as to whether a bond should be granted on both the probation violation and the new offense. A VFOSC is a violent felony offender of special concern. If you are ever convicted of, or if you're currently on probation or charged with a certain crime, by law, the judge cannot give you a bond. A good lawyer will negotiate with the state to get them to agree to a bond if you're on probation. Typically, when the state agrees to a bond and the parties come before the court with an agreement, the judge will ratify that agreement and release you on bond. In the state of Florida, there's a number of crimes that are punishable by life in prison. These are called PBLs. When you are charged with a PBL, you are not entitled to a bond and you will be held no bond. There are generally 2 ways to get a bond when you're charged with a PBL. Your attorney can negotiate a bond with the prosecutor, or you can request an Arthur hearing and ask the court to set a bond. An Arthur hearing is a bond hearing, and it's sort of like a mini trial, where the state has to show that the proof of guilt is evident and the presumption that you're guilty is great. This is a very high bar. They also have to show that you are a danger to the community and you should not be released. If they can meet that burden, you will not get a bond while you're waiting for trial.
But wait, I asked for an Arthur hearing and I won, and I was still held no bond.
Well, that's probably because the state filed what's called a pretrial detention motion. There is a statute in Florida that deems certain offenses as dangerous crimes, and if you're charged with one, the state can request that you be denied bond pending trial. If the state files this pretrial motion, their burden of proof falls significantly lower. So rather than showing the court that proof of guilt is evident and the presumption of guilt is great, they only need to show that there's a substantial probability, based on your past and present behavior, that you committed the offense that you're charged with, and that there is no conditions of release that will protect the community. So as you can see, bond in Florida is a little bit more than $1 amount.